Okay, thank you. And what would be the penalty if one didn't comply with the requirements of this measure to an individual who had a large capacity magazine as defined?
I am just going to need a moment for that. So the penalty would be for each magazine, it would be an infraction punishable by a fine not to exceed $100 per large capacity magazine, or a misdemeanor punishable by a fine not to exceed $100 per large capacity magazine, by imprisonment in county jail not to exceed 1 year, or by both that fine and the imprisonment.
So if someone did not do the 3 requirements in this measure, and they encountered law enforcement in some capacity, what you just said was there could be a $100 maximum penalty plus some jail time if they didn't turn it in. Is that right?
So it would either be an infraction or a misdemeanor. So on the infraction side, that would be just the fine. On the misdemeanor side, it could be fine as well as up to 1 year in county jail.
And do you know if there's any other states that have this requirement in law?
I do not.
And are you aware of any other provisions that we have in law relative to weapons that would require a confiscation that this requires? So, for example, when we did the ban on assault weapons, we required that those who had them in their possession, they had to register them, right? Mm-hmm. We didn't go and take them from them.
Yes.
And this would actually, and so is there anything that we have enacted in California that would actually require a confiscation of, we grandfather things in, but would we actually require them to turn them in?
I think that would be a question better directed for DOJ, because they have a much broader breadth of kind of the various firearm regulations. I think our focus specifically in looking at this initiative is really on kind of the firearms and ammunition sales.
Great, thank you.
Assemblymember Patty Lopez.
Can you detail how the estimated potential increased correction costs or the potential initiative estimates say lately say that low millions of dollars annually?
I'm sorry, can you repeat the question?
Can you detail how estimate the potential increased correction costs of the proposed initiative estimate say lately to say that low millions of dollars annually?
So this refers to page 6 of our handout, that last piece. And so in looking at that, part of our analysis is driven by the change to the penalty for the theft of a firearms. So for those of you who followed Prop 47, that was something that was changed by Prop 47, and so when we say under current law it's a misdemeanor, this measure would change it back to felony. And so we did look at, we used data to kind of look at the number of individuals who would potentially fall within that classification. And so by using those numbers, we did estimate that it would be in, potentially in the low millions of dollars. But again, it depends on the number of violations and how the measure would be enforced.
Okay, thank you. I'm sorry. I started to my left. I have a tendency to go to my left, but Mr. Quirk was next, and then Ms. Melendez.
With regard to confiscation of magazines, wouldn't we be required to pay for the magazines? Otherwise, isn't it a taking?
So that is a question that you may like to direct to the proponents when they present before you next.
Thank you.
I think part of the issue here in terms of the measure is that there are 3 choices in terms of, there's a delay when the measure goes into effect. So it's by July 1st of 2017. And so you have 3 options. You can remove it from out of state. You can sell it to a licensed firearms dealer. And then the third is you can surrender it. And from our conversations, I think that choice was partially to address the takings issue.
Thank you.
That would be a question better directed to the proponents.
Ms. Melendez.
Thank you. Ms. Lee, I just have a very brief question. You have responded to several inquiries about the cost of this initiative. Would you characterize your financial estimate of this initiative as conservative?
I would say that we, to the extent possible from the conversations that we had with both the departments and the stakeholders, we made the assumptions that we thought would be reasonable. We do acknowledge that there is uncertainty in a number of different places. For example, the individuals that would step forward and actually go through the ammunition purchase license authorization. That is something that we continue to look at, but there's not data necessarily in that area specific to that issue. And so some of it will just rely on how it's implemented, to the extent the measure goes into effect, obviously.
Okay, and I ask because this is an elaborate system we're talking about. We're talking about separate accounts. We're talking about development of software. We're talking about making sure systems that there's connectivity between them. It's not a simple task, and so I can't help but think that the cost is going to end up being much more than what we estimate it to be, not on purpose, but just that's how things, usually go. So I just wanted to get your kind of view of if you took a conservative estimate or if you, decided to go higher than what you thought they would need or a little lower, just, your thoughts on how you came up with that number. But I appreciate your response. Thank you.
Are there any other questions from committee members? Thank you, Ms. Lee.
So we can move to our first panel, which is proponents. And we have with us Ari Freilich from the Law Center to Prevent Gun Violence, Julie Leftwich from the Law Center to Prevent Gun Violence, and Tom Willis, attorney. Welcome to the committee. Now, I believe what we discussed was equal time for each side, so that there will be 45 minutes for proponents and 45 minutes for opponents.
Okay, good morning. My name is Juliet Leftwich, and I'm the legal director of the Law Center to Prevent Gun Violence. We are honored to be partnering with the Lieutenant Governor on the Safety for All initiative, and we're grateful to have the opportunity to speak before you today. The Lieutenant Governor is attending a CHP officer's memorial this morning, and he is unable to be with us. I'm going to begin by providing the historical and factual context of the initiative, and then my colleague Ari Freilich will provide in-depth information about each of the initiative provisions. After that, Tom Willis, who is an election lawyer with expertise in statewide initiatives, will discuss the fiscal impact of the Safety for All initiative. I will then close with a few final remarks. The Law Center was formed in the wake of the 101 California Street assault weapon massacre in downtown San Francisco in 1993. That massacre left 8 dead and 6 wounded. The shooting took place at the law firm of Pettit and Martin. I personally got involved because my former law firm was located in that building. I was on the 23rd floor, well below the 35th floor where the shooting took place. But the tragedy affected me profoundly. Within a few days, lawyers from Pettit and Martin had formed a unique organization to use the skills of lawyers to do something about our nation's epidemic of gun violence. I knew I had to get involved. I volunteered for a few years, and then I was able to come on staff, and I've been with the organization ever since. The Law Center is new to initiative work, but we are not new to gun violence prevention policy. We've been doing that work for the last 20 years. We provide free assistance to state and local legislators around the country who are seeking to enact or to defend laws to reduce gun violence. We monitor all state gun laws. We rank state gun laws. We monitor Second Amendment litigation around the country, and we file amicus briefs in those cases. We also provide model laws in a variety of areas. The goal of our work and the goal of the Safety for All initiative is simple: to reduce gun-related deaths and injuries. No one in this room today can deny that gun violence in America has reached epidemic proportions, or that something must be done to stop the senseless bloodshed. Mass shootings, like those that took place at the 101 California Street building, or in Newtown, or in San Bernardino, receive the most media attention, but they're really the tip of the iceberg. Every day, 80 Americans are killed with guns. Today, 80 Americans will die from gun violence. In fact, since the 101 California Street massacre, 700,000 Americans have died from gun violence in this country. In California, nearly 10,000 people die each year. 10,000 people are shot each year, and approximately 3,000 of those die. The reason for these staggering statistics is clear. Our nation has incredibly weak gun laws. The U.S. has the weakest gun laws of all of the industrialized nations in the world, and we have the highest rates of death related to guns. The American Journal of Medicine found recently in a study that the U.S. gun homicide rate is 25 times higher than that of other industrialized nations in the world. It isn't that Americans are inherently more violent than people in other countries, or that we suffer from more mental illness. It's just that other countries have sane gun laws to keep guns away from dangerous people, and we do not. One of the first priorities of the Law Center was to work for the passage of the federal assault weapons ban. That was important to us as an organization because the assault weapons used in the 101 California Street shooting were purchased legally in Nevada, where assault weapons were not prohibited and still are not prohibited, even though at the time they were prohibited here in California. In 1994, Congress did enact a federal assault weapons ban, which included also a ban on the manufacture and sale and possession of large capacity ammunition magazines. And the possession piece is what is included in the initiative. Unfortunately, however, the law had a 10-year sunset provision, and it was allowed to expire in 2004. Because Congress is beholden to the gun industry, it has repeatedly failed to enact even the most modest gun reforms over the past few decades, despite overwhelming public support for those measures. That's why it's so important for states to step up. Fortunately, we've had many courageous leaders here in California, including several members who are on this committee. And the legislature has led the nation in adopting strong gun safety laws here in California over the last 20 years. Despite this progress, however, much work remains to be done. California's laws still have loopholes that allow dangerous people to obtain guns and ammunition and then commit acts of gun violence. For example, our laws allow criminals to buy ammunition without any background check. They allow for the possession of large capacity magazines, even though the sale and manufacture of those dangerous military-style items has been banned since 2000. Our state laws also provide no clear process for convicted felons to relinquish their weapons once they become prohibited. As a result, as Senator Leno mentioned, we have a mountain of people who are in the APPS database. That's the database of armed and prohibited people. There are now a backlog of 17,000 people in that database who own more than 34,000 guns, including thousands of assault weapons. When we were approached by the Lieutenant Governor to help craft this initiative, our recommendations were designed to close the loopholes that currently exist in our state laws. Our recommendations were also based on legislation that had been shaped and vetted by the legislature, often after similar laws had been passed at the local level with our assistance over the last 20 years. Our recommendations were also consistent with the longstanding priorities of our gun violence coalition partners around the state. I'm now going to turn things over to Staff Attorney Ari Freilich, who will provide much more detail about each of the initiative provisions. As you'll hear, the provisions are overwhelmingly supported by the vast majority of Californians, and none of the provisions are radical. They're simply intended to keep guns and ammunition out of dangerous hands.
Thank you.
Morning. My name is Ari Freilich. I want to thank you for your committee's work to keep the public safer and freer from violence. And thank you for the opportunity to speak with you today to discuss in detail how this ballot initiative would further that shared goal. As Juliet mentioned, this issue is personal to us. It's the people we work with and for. Well over 1 million men, women, and children were shot in this country in the last decade. And we know painfully, unceasingly well, that behind that number, the epidemic's impact is felt one name and voice, one bullet, one brutal personal tragedy at a time. And we're here because we believe reasonably that more can and should be done to protect California's families and keep lethal weapons, lethal products out of dangerous hands. The Safety for All Act would build on California's proven track record in this area and expand what has been shown to work in local governments here in California and elsewhere by proposing a package of 7 major policy reforms. And I apologize to the extent that my remarks are duplicative of Ms. Lee's presentation, but I'd like to walk you through each of these proposals and be absolutely clear and specific about what we're advocating and why these policies matter for California's families. The Safety for All Act's first major policy reform addresses a dangerous and costly enforcement gap in removing firearms from prohibited criminals at the point of conviction. As you know, California and federal law prohibit certain categories of dangerous individuals from possessing firearms. And when individuals fall into these prohibited categories, existing California law requires them to relinquish possession of any firearms they previously owned or controlled. However, state law provides essentially no mechanism to ensure that individuals who have been convicted of a prohibited criminal offense, no matter how serious, actually relinquish possession of their firearms upon conviction. Existing California law, to address your point, Senator Leno, does currently establish a clear and enforceable process for individuals subject to certain protective orders, such as domestic violence restraining orders, GVROs, to lawfully relinquish their firearms for the duration of that prohibiting court order. And importantly, that law has teeth. It requires such individuals to provide written receipts to a court of law, verifying that they actually relinquished the firearms within specified timeframes. This existing law also authorizes courts to issue warrants to recover illegally owned firearms from abusers who failed to comply. Studies have shown that this process has been highly effective at removing illegal firearms from individuals covered by the law. Since 2000, when California first mandated that all domestic violence protective order respondents relinquish their firearms pursuant to this policy and verify compliance with the courts, the number of firearm-related domestic violence calls to law enforcement has fallen by 44%, even as the overall number of domestic violence calls to law enforcement has risen substantially. California has thus far failed to extend this effective best practice to firearm relinquishment in other contexts. As a result, according to DOJ, and as you well know, thousands of prohibited individuals illegally retain possession of firearms each year and are added to our APPS database. More than 7,700 individuals were added to that database in 2014, of which at least 42%, more than 3,200 people, were individuals who illegally retained firearms after a new criminal conviction. The consequences of this noncompliance are both dangerous and costly. The State Department of Corrections and Rehabilitation reported that in 2013, over 8% of California's newly admitted felony inmates and nearly 10% of parole violators sentenced to a new prison term were incarcerated because of illegal weapon possession charges. At the end of 2013, California taxpayers were paying to incarcerate more than 4,700 people whose controlling, most serious offense was illegal weapon possession. This number does not encompass the thousands more incarcerated for crimes related to the use of those illegal firearms. DOJ has also reported that over a 3-year period, nearly 6,000 Californians were arrested solely because they illegally possessed firearms after a prohibiting criminal conviction. Nearly 7,000 more were arrested over that period for offenses that included that charge. Instead of implementing a proactive relinquishment process on the front end, California currently requires teams of law enforcement officers to go door to door to recover these prohibited offenders' weapons. While these enforcement efforts have been essential and constructive, this process imposes significant manpower and financial burdens on law enforcement and, in too many cases, proves too little, too late to prevent prohibited offenders from using firearms to perpetrate violence in our state. It would be cheaper, safer, and more effective to also remove offenders' illegal firearms at the point of conviction. And the Safety for All Act would do just that by implementing a clear and enforceable process for the relinquishment of firearms by prohibited offenders. More specifically, Beginning January 1, 2018, this measure would require courts to order prohibited offenders to relinquish their firearms and to provide the offenders at the time of conviction with a standard relinquishment form. The form would, among other things, inform the defendant that they are required to relinquish all firearms within specified timeframes by selling or transferring the firearms to a licensed firearms dealer or by transferring them to law enforcement. It would require defendants to declare any firearms that they possessed at the time of conviction and to name a consenting designee or law enforcement agency to relinquish those firearms on the defendant's behalf. Most importantly, this measure would require the defendant or designee to file the completed relinquishment form with a court-assigned probation officer, along with receipts from the law enforcement agency or licensed firearms dealer who took possession of those firearms, to verify that the offender in fact relinquished all firearms prior to sentencing as required. The measure would require the assigned probation officer to include in his or her standard pre-sentencing report to the judge information regarding whether the offender properly relinquished all firearms indicated on the relinquishment form or by the AFS database. Courts would be required to verify that relinquishment occurred before final disposition of the case, and when the court finds probable cause that the defendant failed to comply, the court would be required to order the search for and removal of the defendant's firearms at any location where the judge has probable cause to believe the defendant's firearms are located. This is similar to the domestic violence restraining order context. This relinquishment process implements best practices from that domestic violence restraining order context by providing clear and mandatory procedures to all prohibited offenders, by expressly requiring proof of relinquishment, and by requiring further enforcement action if the offender fails to comply with the law. It would be an important overdue step to proactively remove illegal guns from our communities and would help significantly reduce growth in the apps backlog. The Safety for All Act's second major policy reform addresses a massive enforcement gap regarding dangerous persons' access to lethal ammunition. Existing California and federal law both prohibit convicted felons, domestic abusers, and the dangerously mentally ill from purchasing or possessing both firearms and the ammunition that makes firearms deadly. But state and federal law do essentially nothing to enforce that law, to prohibit dangerous people from purchasing ammunition. As a result, convicted felons and other prohibited persons in our state are able to have unlimited quantities of ammunition delivered to their door as if ordering a pizza, without showing identification, passing a background check, with no questions asked. Law enforcement authorities also have no idea who is selling ammunition in our state because individuals selling this lethal product do not have to be licensed, pass a background check, or document their sales or business practices in any manner. As the California Police Chiefs Association noted before the Senate Public Safety Committee in 2013, it is easier to purchase ammunition in California than a packet of cigarettes or allergy medicine. This lack of regulation has dangerous consequences. Researchers examining ammunition sales from 10 retail outlets in Los Angeles over a 2-month period found that felons and other illegal purchasers had obtained 10,000 rounds of ammunition in that 2-month period from those 10 stores alone. In the wrong hands, every one of those bullets posed a significant threat to human life in our state. The California legislature previously recognized the importance of closing this gap in our state's gun laws. In 2009, Governor Schwarzenegger signed then Assemblymember De Leon's AB 962, which would have imposed important record-keeping requirements on handgun ammunition sellers, and would have required handgun ammunition sales to be conducted in person instead of by mail. Unfortunately, that law is being challenged in ongoing litigation related to the allegedly vague definition of handgun ammunition and is subject to an injunction preventing its enforcement. The Safety for All Act would remedy that situation and help keep all types of ammunition from falling into dangerous hands by requiring ammunition sellers to be licensed, to conduct background checks on their purchasers and their employees, and to submit records of ammunition sales and lost or stolen ammunition to law enforcement. To drill down more specifically, starting January 1, 2018, individuals who sell more than 500 rounds of ammunition in a month would be required to obtain a license from the Department of Justice. DOJ would start accepting applications for ammunition vendor license 6 months in advance. The licensed firearm dealers would not need to apply. They would be automatically deemed ammunition vendors. DOJ would be authorized to issue these licenses to individuals who provide specified documentation, including appropriate local business or regulatory licenses, if applicable, and a certificate of eligibility verifying that they passed a background check. As with firearm dealers' licenses, an ammunition vendor license would be valid for 1 year and subject to forfeiture for legal violations. The next set of policies aim to align firearm and ammunition seller requirements. Ammunition vendors would be required to obtain a certificate of eligibility from employees who handle or sell ammunition, verifying that they passed the background check. Beginning January 1, 2018, ammunition sales by unlicensed sellers would generally have to be conducted by or processed through a licensed ammunition vendor, just as firearm sales by unlicensed individuals must currently be processed through a firearms dealer. To be clear, this requirement applies to sales. not to the transfer of an ammunition to a hunting buddy in the field or at a shooting range. Ammunition obtained remotely over the internet or from out of state could be initially shipped to a licensed ammunition vendor for physical delivery to the purchaser, similar to existing requirements for firearms. Other states, including New York and Massachusetts, and some cities in California, including Los Angeles, Sacramento, and Oakland, have already enacted these restrictions regarding mail-order ammunition shipments. Additionally, beginning January 1, 2019, a licensed ammunition vendor would be required to maintain and report to DOJ records of ammunition sales in a manner similar to DROS records for firearm purchases. This act would also extend existing law governing the straw purchase of firearms to also apply to ammunition, making it a misdemeanor to traffic ammunition to a person with knowledge that he or she is funneling that ammunition to prohibited persons. Finally, and importantly, beginning July 1st, 2019, licensed ammunition vendors would also be required to verify at the point of sale that ammunition purchasers have passed a background check. Instead of making purchasers wait at the sales counter, the law would require them to apply in advance for an ammunition purchaser authorization, essentially an electronic certificate of eligibility, good for 4 years. DOJ would start accepting applications for these authorizations 6 months prior and would be required to process those applications within 30 days. So individuals should not experience delays in obtaining this approval. If the seller is a firearms dealer, he or she may also sell ammunition in the same transaction as a firearm with only the firearm background check required. Once DOJ receives a background check application, it would conduct a full background check, approve all eligible applicants, and maintain an electronic database of authorized purchasers' driver's license or other identification numbers. DOJ would charge a fee not to exceed $50 to conduct a background check on first-time applicants, and this approval would be good for 4 years unless the person fell into a prohibited category in the interim as a result of a new criminal conviction or other event, in which case DOJ would promptly remove his or her identification number from the electronic database. At the point of sale, ammunition purchasers would simply present their ID to the vendor, who would enter the ID number into DOJ's database of approved purchasers. That database would then instantaneously inform the vendor whether the person has or has not passed a background check to purchase ammunition. 4 other states have already enacted ammunition permit requirements. And we believe that this approach, a more nimble electronic version, blends the convenience of the permit to purchase schemes with a more timely accuracy and effectiveness of a point-of-sale background check. New York also enacted a law requiring point-of-sale ammunition background checks, but it has delayed implementation of that law because, unlike California, New York does not maintain its own background check system database of prohibited persons and needs time and resources to build what California already has from scratch. I'd also like to note that this act includes certain exemptions to these rules, such as for individuals to lawfully buy ammunition for use at a shooting range without a record of sale or background check required. If the shooting range is also a licensed ammunition vendor, they could also sell ammunition for use both on and off the range, so long as they conduct a background check and document the sale. And just to speak about the effectiveness of these proposals, the California Police Chiefs Association called for enactment of these policies in 2013, noting in a statement to the Senate Public Safety Committee that, quote, each year, millions of rounds of ammunition are sold to felons and other prohibited persons at gun shops and sporting goods across our state. By requiring ammunition vendors to obtain a license to sell ammunition and ammunition purchasers to submit to background checks, this legislation would effectively limit criminal access to the fuel that drives gun violence. We agree. These policies would build on the success that local governments in California have had using more limited record-keeping ordinances to identify and prosecute armed prohibited persons. In Sacramento, for instance, a local ammunition record sales requirement, record-keeping requirement, helped law enforcement discover that in an 18-month period, 229 felons and prohibited persons illegally purchased ammunition in that city. The DA used these sale records to file charges against 197 illegal gun owners. Others were indicted in federal court. The vast majority of these cases were resolved in convictions. Law enforcement officers recovered 160 firearms from these individuals, including explosive devices and thousands of rounds of ammunition during this period. Ammunition background checks have also proven effective at preventing firearm violence. The ammunition permitting laws on the books in 4 other states are weaker than what is proposed here because a person who becomes prohibited after receiving a physical permit would still be able to present that permit to obtain ammunition until it expires. Even so, there's evidence that those licensing requirements have significantly improved public safety. CDC data show that New Jersey and Connecticut both experienced significant reductions in firearm homicides after recently adopting their permitting laws in 2008 and 2013, respectively. The number of firearm homicides in Connecticut declined by 36% between 2012, the year before Connecticut enacted its law, to 2014, the first full year in which the law was in effect, and that is excluding the 26 individuals massacred in that state in 2012 at the Sandy Hook Elementary School. And 2012 is not a cherry-picked data point. The number of firearm homicides in Connecticut was 42% lower in 2014 than in 2011, 43% lower than in 2010, and 30% lower than in 2009. The state's non-firearm homicide rate did not experience this dramatic decline, and in fact, moderately increased over this period. New Jersey State Commission of Investigation released a report in 2007 showing that nearly 3/4 of its retail firearm outlets had sold ammunition to individuals with criminal records. One store alone had sold more than 15,000 rounds of handgun ammunition to 42 felons over a 4-year period. As a result, the commission formally recommended that the state adopt laws to require ammunition sellers to retain ammunition sale records and to require purchasers to present a valid permit obtained pursuant to a background check in order to acquire ammunition. Those laws became effective in New Jersey in mid-2008 and have similarly resulted in significant reductions in firearm homicides in New Jersey. This data is consistent with what we know about background checks. They effectively reduce the incidence of gun violence by keeping weaponry out of the hands of those who should not have them, with relatively minimal inconvenience to law-abiding, responsible citizens. California voters agree. A January 2016 California field poll confirmed that 80% of voters in our state support requiring people to pass a background check in order to buy this lethal product. The Safety for All Act's third major policy reform would require gun dealers to conduct employee background checks and to report lost or stolen ammunition as well as firearms. Currently, California law authorizes but does not require firearm dealers to conduct background checks on their employees to ensure that they are not dangerous or prohibited persons. Because gun dealers' employees have access to such a high volume of firearms, corrupt or criminal employees are a major source of crime guns, responsible for nearly half of the total number of trafficked firearms uncovered in ATF investigations. In ATF trafficking investigations in which a gun dealer or employee was implicated, ATF discovered that 350 black market guns were involved per investigation on average. In the wrong hands, again, every one of those guns posed a significant threat to human life. If individuals must pass a background check to obtain those firearms, we believe it is common sense that the employees selling those weapons should also pass a background check too. The Safety for All Act's fourth major policy reform would help reduce the lethality of mass shooting events in our state by making it illegal to possess the kind of military-style large-capacity magazines that enable these killings. I'd like to thank and acknowledge Chairwoman Hancock for your strong, consistent leadership on this issue. And as you've long pointed out, these magazines, some capable of holding 100 rounds of ammunition, are designed for offensive purposes to allow a shooter to continue firing large numbers of bullets and multiple targets without reloading. They're the common thread uniting most of the high-profile mass shootings in our country, including the massacre that prompted the founding of our organization, as well as the Cleveland Elementary School shooting in Stockton, where a gunman fired 106 rounds in 3 minutes, killing 5 children and wounding 30 others. The 2011 Tucson shooting, in which a gunman shot more than 30 rounds and killed or injured 19 victims in the span of 15 seconds. 2012 Aurora movie theater shooting, where a gunman shot 70 people in less than 10 minutes. And the 2012 Sandy Hook shooting, in which a gunman fired 154 rounds and killed 26 children and teachers in less than 5 minutes. In so many of these incidents, the shooter was ultimately subdued only when he finally paused to reload. And studies have found that in mass shootings where large capacity magazines were used, more than twice as many victims were shot, 57% more victims were killed compared to mass shootings where the gunman used conventional magazines. Behind those data points were real and, in too many cases, preventable deaths. A classroom of children escaped to safety at Sandy Hook when the shooter finally stopped to reload. Conversely, in Tucson, a 9-year-old girl was struck and killed by the shooter's 13th bullet. She may be alive today if he had to pause to reload after his 10th round. The California legislature recognized long ago that these military-grade magazines have no place in our communities. Since January 2000, California has generally prohibited individuals from manufacturing, importing, selling, giving, or transferring these LCMs. The legislature did originally intend to grandfather possession of these magazines that were lawfully obtained before 2000. But because they do not have any identifying marks to indicate when they were manufactured or sold, police officers who come upon a stash of LCMs are, practically speaking, often unable to determine whether or not they were lawfully obtained prior to 2000. Instead of serving as a limited grandfathering clause, this gap has therefore made California's existing restrictions nearly impossible to enforce. The availability of magazine conversion kits, which allowed individuals to self-assemble and possess new LCMs before the kits were finally restricted in 2014, also significantly undermined existing law's effort to keep these magazines off the streets. The Safety for All Act would close this dangerous gap in our laws and protect our state from mass shootings, providing a clear mandatory process for individuals to legally dispose of their LCMs by removing them from the state, selling them to a licensed firearm dealer, or transferring them to law enforcement. And as Juliet will discuss in a few moments, this is not a takings, as the courts have made clear. The Law Center has supported adoption of similar legislation to close grandfathering loopholes in states like New York, New Jersey, and Hawaii, as well as at the local level in California, Los Angeles, Oakland, San Francisco, and Sunnyvale, among others. These types of laws have been repeatedly upheld in the federal courts. In Fyock v. Sunnyvale, for example, the Ninth Circuit upheld Sunnyvale's LCM ban and noted that the city presented credible evidence demonstrating that the use of LCMs results in more gunshots fired, results in more gunshot wounds per victim, and increases the lethality of gunshot injuries. The court ruled that the city maintained a strong interest in protecting the public against their potential use. A January 2016 California field poll confirmed that a strong majority of California voters support efforts to rid our communities of these magazines. The Safety for All Act's fifth major policy reform would help law enforcement break up gun trafficking rings and return lost or stolen firearms to the rifle owners by requiring individuals to notify law enforcement if their firearm has been lost or stolen. According to ATF data, private individuals reported the loss of more than 173,000 guns nationwide in 2012, but researchers estimated that more than 500,000 firearms are lost or stolen from private residences each year. This discrepancy suggests that the majority of lost or stolen firearms may never be reported, significantly hindering law enforcement efforts to trace the source of these crime guns and to prevent weapons from falling into dangerous hands. This act would address this problem by requiring every person to report the loss or theft of firearms to local law enforcement within 5 days of the time the person discovered or reasonably should have discovered that his or her firearm was lost or stolen. Laws requiring the reporting of lost or stolen firearms have been enacted in 10 other states and in 14 local jurisdictions throughout California, including San Francisco, Sacramento, Oakland, and Los Angeles. These laws are useful to law enforcement for several reasons. First, when a crime gun is traced by law enforcement to the last purchaser of record, the owner may claim that the gun was lost or stolen to hide his or her involvement in the crime or in gun trafficking. Reporting laws provide an important tool for law enforcement to detect this behavior and charge criminals who engage in it. Individuals who repeatedly report their guns lost or stolen also put law enforcement on notice that they may be intentionally trafficking those firearms to prohibited persons. Second, reporting laws help disarm illegal gun owners. When a person who legally owned a gun falls into a prohibited category as a result of a domestic abuse restraining order or conviction, for instance, it is crucial that law enforcement remove the firearm from his or her possession as required by existing law. But when required to relinquish those firearms, a prohibited offender may falsely claim that his or her gun was previously lost or stolen. Mandatory reporting laws provide a check against that behavior. Third, the reporting requirement helps law enforcement track down missing guns and return them to lawful owners before they fall into dangerous hands. And finally, reporting laws make gun owners more accountable for their weapons and help protect rightful gun owners from unwarranted criminal accusations when a gun that was lost or stolen from them is later recovered at a crime scene.
Mr. Freelick.
Yes, sir.
We probably misspoke. We have 45 minutes in total. We're now at the 30-minute mark, and I know the committee wants to ask some questions. So in that, if you could.
Just very briefly.
Yes. And I don't want you to infringe on Mr. Willis's time either.
I appreciate that, sir. I'll just very briefly move on then to the Safety for All Act 6 policy reform would help correct a dangerous unintended consequence of Prop 47 by making clear that the theft of a firearm is a felony, regardless of the firearm's market value, and by making it illegal for individuals who are convicted of a misdemeanor instead of felony firearm theft as a result of Prop 47 to possess firearms for 10 years thereafter. I want to acknowledge and thank Vice Chair Melendez for your work to highlight the need for this fix. And finally, the Safety for All Act would ensure that the Department of Justice shares crucial data about dangerous individuals with the FBI's background check system database to codify current responsible best practices so that future leaders in the state will continue as a matter of law to sustain effective background check procedures and systems at the state and federal level. And thank you for your time.